Well, speaking of corporate money, your book, which was, how many years ago?
It was published in 2002.
2002 is so on the money, The Rise of Corporate Dominance and the Theft of Human Rights. Really a book that affected my thinking very deeply, and my hat's off to you. From the perspective of knowing a lot about this issue, do you see any potential solutions to the Citizens United Supreme Court ruling? Anything that activists can do, or any pressure that we can put on legislatively? Jerry Nadler was here last week and is part of a committee that Pelosi has appointed to try to look at it, so there's some movement there. But what would be your suggestion of what we do so we don't just slit our wrists over it?
The short answer is we need to amend the Constitution to, in the 14th Amendment, insert the word natural before the word person, so that corporations can no longer claim personhood and can no longer claim that the Constitution protects their rights. They don't have rights, they have privileges, which is a whole different thing. The longer answer is how this book came about, if I may.
Sure.
I started out writing a book about Jefferson. We had just, when we moved to Vermont, we'd bought this house in Vermont. In the attic, we found this 20-volume set in pretty bad shape. Nobody had, I think, opened the attic since 1930, but it was this 20-volume set of the collected writings of Thomas Jefferson that has only once ever been published in 1909. And I spent the next year and a half, 2 years reading it. His letters, his personal diaries, I mean, there's just incredible stuff in there. And so I wanted to write a letter about, or a book about Jefferson's vision of America and how America has become since then, which started out as this book. In fact, the first couple chapters are about Jefferson's view of America and commons and why, you know, the founders and all this kind of stuff. And as I was moving along and reading other histories along with Jefferson about the history of the United States, because I wanted to make this a big arc book, I read, for example, Charles and Mary Beard's famous 1932 History of American Civilization, which was probably the most important historical work written in the first half of the 20th century about the history of the United States. And more recently, David Korten's When Corporations Rule the World, which came out in the late 90s. I was doing this in 2000. I started researching this, or writing this book. It was 99 I really started, but 2000 I was banging out outlines and things. And they were all saying that in 1886, in a Supreme Court decision called Santa Clara County versus Southern Pacific Railroad, the railroads had come into the court, had come to the Supreme Court and said that because the way that their property taxes were being assessed in Santa Clara County was different than it was being assessed in Santa Ana County, that was a form of discrimination. And this was 1886. In 1873, 13 years earlier, the 13th, 14th, and 15th Amendments had been ratified following the Civil War, stripping slavery out of the Constitution. And the 14th Amendment explicitly says, no person shall be denied equal protection under the law. In other words, you can't run a lunch counter and say, you know, white people can sit here, but black people can't, for example, or whatever. You know, you're entitled to protections under the law, but this other person isn't. So historically, I mean, going all the way back to the 7th century in England, all of British common law and early American law identified two types of persons at law. These very precise legal definitions. There are natural persons, which is you and me, and there are artificial persons, which is corporations, churches, and governments. And they had to have, this latter category, had to have some sort of person status so that they could pay taxes, they could own land, they could enter into contracts, they could sue and be sued, these kinds of things. And they were always differentiated. But the 14th Amendment doesn't say natural persons, it says persons. So the railroads came in and said, you know, the 14th Amendment says persons. We're being discriminated against. We're getting different levels of taxation in 2 different counties, and that's unfair discrimination. It's illegal discrimination. And, you know, this is an argument that they took to the Supreme Court. And in fact, in the Ninth Circuit Court here in California, Stephen Field was the Supreme Court Justice who also was the Ninth Circuit Justice. He agreed with them. And he said, yeah, corporations are persons. They're artificial persons, but they're persons. The 14th Amendment only says persons. And so that this is illegal discrimination. Now keep in mind, we still had legal apartheid in the United States, and women couldn't even vote yet, but nonetheless they said this is legal discrimination, we've got to give the railroads these rights, and they kicked it up to the Supreme Court. So I read in all these history books that in this 1886 case, the court gave corporations the rights of persons. And ever since then, they've been using those rights in pretty nasty ways. They've been using the Fourth Amendment right of privacy to say things like, we don't have to tell you what we know about asbestos and tobacco. Our books are no longer open to the public. They've been using the Fifth Amendment right against self-incrimination to say, well, there may be something going on, but we don't have to tell you about it. They're using the 14th Amendment right of equal protection to say you can't keep a hog farm out of our neighborhood or a Wal Mart out of our neighborhood because that's discrimination, and so on. And the First Amendment is the one that just got argued, and at the Supreme Court building. So I went down there and found Paul Donovan is the guy's name, who is the head librarian there. And said, Paul, I'm looking for that 1886 case where corporations became people. And he says, oh, you mean Santa Clara County versus Southern Pacific Railroad? And I said, yeah. And so we go back in the stacks, and he finds the original 1889 bound, Brooks and Biddle or whatever it was, published in New York book, and pulls it off the shelf, and blows the dust off it, and opens it up and says, okay, here's the commentary on the case, the head note, and here's where the case begins right here, and it runs like 16, 18 pages. And so I sat down and I read this case. And there were all these arguments about fence posts and taxes and how it should be done, and you get to at the very end of the case, and you can read this online, it's at the Supreme Court website. You get to the very end of the case, and the judges say, there were also constitutional issues that were presented before the court. I'm paraphrasing here. There were also constitutional issues that were presented before the court, but we didn't need to address them because we were able to find the specific remedy for this case in California law. So I'm going, wait a minute, this doesn't say corporations are persons. It doesn't even say that there's anything about the Constitution in this case. So I went back to Paul and I said, Paul, I think I got the wrong case here. And he says, no, I'm pretty sure that's the right case. And the librarian for the Supreme Court, he'd know this kind of stuff. And so he comes back over with me and he says, did you read the head note? Maybe I think he thought I was skimming it, and he said, so let's check out the head note because that's kind of a guide to the case. It's a commentary written by the clerk. And so we flip back 2 pages to the head note, and the first paragraph of the head note says, corporations are persons under the 14th Amendment and entitled to equal protection under the law. And he says, well, there it is. Okay, so it's got to be in here someplace. And I said, no, wait a minute, look at this. And I flipped the end and said, read that paragraph. And he reads it and goes, whoa. And I said, what does it mean? He says, I don't know, you need to talk to a lawyer. So I paid my 75 cents and got copies made and went around the corner to a friend of mine who was a lawyer and said, Jim Ritvo. And I said, Jim, I want to talk to you about Santa Clara County versus Southern Pacific Railroad. And he says, oh, you mean when corporations became people? And I said, yeah. And so I laid out the papers on the table and I said, okay, here's what it says in the head note. Here's what it says in the decision. And he looked at it and he was like, well, he said a word you can't say on the radio or on television, and with holy before it. And I said, what is it? And he said, it's a mistake. He said, the head note contradicts the decision. So I thought, oh, we've got it. We can bring down the whole corporate edifice. So, one of the cool things about living in Vermont, in a little state like Vermont, is when you call the Secretary of State's office, she actually answers the phone. And he says, you need to call a constitutional lawyer, somebody who really knows this stuff. You ought to call Deb Markowitz. And so I called up, and Deb answers the phone. And I said, Deb, you don't know me, but I had your sign in my front yard last year. And we have some mutual friends, and I wanted to talk about the 1886 Santa Clara case. And she says, oh, you mean the one where corporations became people? And I was like, yeah. So I shared that with her, and her response was very similar to Jim's. And I said, does this mean that we can just take all this away? All this power that these corporations have gained over the years by claiming that they have rights instead of just privileges? And she said, well, unfortunately not, because there have been at least 30 cases, Supreme Court cases, that have referenced the head note. And she said, the court could reference Donald Duck. Doesn't matter once they decide something. So while that case might not be precedential, the precedent. There are other cases. The next case became the precedent. So I've been on a campaign since 2002 when I wrote the book to inform Americans about the fact that the court never said this.